the way that inference works on the LSAT is you have to find something that 100% must be true based on the statements of fact, even though it isn't necessarily explicitly stated. So, what you're looking to do is find an answer choice that must be based on those facts without going too far. And the way you can think about this is, for instance, if I were to walk into a room and I were wet, the other inhabitants of that room can't necessarily say that it's raining outside or that there's a pool in the backyard because it may not be raining. I might have encountered some other liquid, and it may not even be water that I encountered. I could have taken my morning coffee bath. We don't know how I would have gotten wet. But in that circumstance, we can infer that I would not be dry. So let's keep that example in mind as we work through these three questions of this passage, starting with number 4. So we read, the passage most strongly suggests that its author holds which of the following views regarding the court's $7.5 million award of damages to the Tlingit and Haida tribes. So we're going to highlight this part here, and it's that term suggests that indicates we're looking for an inference, not just what the passage stated explicitly. So we're going to scroll down to where we might recall that $7.5 million in damages was located. And if you want to highlight that for reference, you can do so in another color. So I just chose the pink, and I see that's exactly what we're talking about. And I want to read at least a sentence above and a sentence below to reacquaint myself with the relevant information. So starting at the top of this paragraph, because the Alaska Native Allotment Act was implemented in a manner directly contrary to Native law and values, few applicants for allotments were successful, and the majority of lands in the Tongass remained in the hands of federal and private interests. In 1912, Southeast Alaskan natives organized to collectively address land issues, and at long last, in 1968, the Tlingit and Haida tribes were awarded $7.5 million in damages resulting from the establishment of the Tongass National Forest. However, even then, the court did not award accrued interest or recognize native fishing and navigation rights. So I'm going to just highlight a little bit more in pink here so that I can clearly contrast the information in each choice against this information that we know is the relevant subject matter for this question. And we're going to go back into the answer choices, seeking reasons to eliminate, or a fact that is 100% guaranteed about the author's views regarding this $7.5 million damage award. So, starting with choice A, the award was less than the total amount of monetary compensation that the courts should have awarded to those tribes at that time. Now, you might be saying, well, how did we know whether it should have been more or less? Well, if we come back over here in the pink highlight we just made, we see the court did not award accrued interest. And if interest is present and it wasn't paid out, then the amount of compensation wasn't big enough, according to the author, even though the author doesn't explicitly state that. So choice A is guaranteed to be true, and we're going to just move more briskly through the remaining answer choices, seeking reasons to eliminate, starting with choice B. The court's action was laudable. Well, the author, if anything, seems to think it wasn't enough. So laudable means a good thing, should be kind of applauded. Get rid of choice B. Then choice C, in conjunction with the restoration of Native Alaskans fishing and navigation rights, the award formed part of a satisfactory settlement. Again, I'm highlighting satisfactory settlement because the author said they didn't get everything they should have, according to what we highlighted in pink. Then choice D, the court's decision set an important legal precedent. Well, we're not talking about any sort of legal precedent, so we'd eliminate choice D. And then choice E, the award was inappropriate because the tribes did not consider money to constitute adequate compensation for natural resources. This is a bit of a trap because it may seem like the tribes weren't happy with what they got, but it doesn't mean that they didn't want money at all. So we can eliminate choice E, and we see how to address this type of inference question as we move on to the next problem. Now, if you did use the highlight tool for a prior question, just select that eraser icon so you can erase what was there previously so that you don't use it in an accidental fashion, overemphasizing what you previously highlighted. Now, for number 5 here, I'm going to select that pink again in case I want to highlight anything. And we see the phrase strongly supports, which is another inference indicator. So we're looking for something that must be true about the Haida and Tlingit nations. And we know that the Haida and Tlingit tribes were awarded that money. But if we scroll back up on the left hand side here, we might want to go find the other reference to Haida and Tlingit nations. And we find that up here. And again, you could use the highlight tool to focus specifically on the term or location reference. And we can see that or in this surrounding area, we'll just read a sentence above and a sentence below. It says, in a series of presidential proclamations from 1902 and 1909, the United States government set aside some 17 million acres of southeastern coastal Alaska to comprise the Tongass National Forest. Although much of the territory was thus declared to be U.S. government property and no previous officially registered ownership, it was in fact traditionally held and used by the members of the Native Alaskan, Tlingit, and Haida nations. Recognizing the need to address issues concerning Tlingit and Haida land ownership in the Tongass National Forest, the U.S. Congress in 1906 passed the Alaska Native Allotment Act, which was designed to establish legal recognition of individual Native Alaskans' private ownership of the land and had traditionally been used by their people. So we are focusing on these two nations, and we want to find an answer choice that, even though it isn't explicitly stated, must be true about these peoples based on the information explicitly written. Now, choice A, they left the Tongass region. Well, they didn't leave. They're still there. So, and sell primarily in other parts of Alaska, that certainly isn't stated. So we can eliminate choice A. And then choice B, prior to the 1968 court decision, they were offered and they refused various forms of monetary compensation for the taking of the Tongass. Well, this is where you will have one question often build on another in reading comprehension passages on the LSAT. So we just read that third paragraph for the prior question, and we've got it still in mind that no, they didn't refuse anything. It just took a really long time for them to get any monetary compensation. So we can eliminate choice B. Then we've got choice C. Prior to the 1968 court decision, they were adamantly opposed to any form of monetary settlement. Well, no, they've tried for a really long time from the reading we just did, and I don't want to go reread. I know what that information was based on the prior problem. Then choice D, they traditionally considered the tribe as a whole rather than any individual or family to be the owner of the land they occupied. Well, this is the trap because it's not the tribe as a whole, it is individuals and family because that's who's going back and trying to get their land. So this is actually a reversal of the information. But if we scroll down, and this is what makes these types of questions particularly time consuming, you want to avoid going back and forth and reading and hunting and pecking. And you'll note we didn't even use this find text tool because it's kind of clumsy. Even if I try to search for Haida, for instance, you can see it does this weird little highlighting in the question stem here, like spaces it out in some fashion. You can see Haida now is spaced out strangely in the highlights that we already had. So you don't want to engage with this tool all that much. But if we go back down to where we just read for the prior problem, we know that the Southeast Alaskan natives, meaning the Haida and the Tlingit, began addressing these land issues in 1912. That's a long time prior to 1968. So they certainly did persevere for many years in their quest to get their land rights recognized. And so the correct answer here is going to be choice E. Now, remember, if you do highlight something like that 1912, I'm going to come up here and erase it just so that I don't get distracted for the next question. But I might as well just leave this part up top. You could be a little bit loose once you start getting further into the passage as far as cleaning things up, but we'll move to one more question before we finish up our little exercise here. So once again, with question 6, we see the word suggests. So this, once again, is going to be another inference task. So 6 reads, the passage suggests that which one of the following applications for government recognition of land ownership under the Alaska Native Allotment Act would most likely have been approved, assuming that all other relevant factors were equal. So we're going to just highlight in pink following applications for government recognition of land ownership under the Alaska Native Allotment Act would most likely have been approved. So we know that there was this information down here about what the act allowed. And again, you can highlight in pink and get deeper into the specific detail questions because the main ideas are going to be less important to review because you'll hopefully have been able to address all of the main idea questions in order at the outset. Now, this passage just happened to only have the first main idea question, but in a future video, we'll talk about how you will actually, in many cases, consider doing the set of 5, 6, 7, 8 questions for a passage out of order to maximize efficiency in terms of getting the main ideas first and then dealing with each specific detail, purpose, inference, or application question later on. So we know we're trying to figure out what of the answer or which of the answer choices would have satisfied the requirement of this act. So again, try to avoid scrolling, and we're just going to look at choices A through C first. A reads, the head of a Tlingit household, okay, that's good, applied for title to 18 acres adjacent to the Tongass National Forest. Well, no, we don't want it to be adjacent. We want it to be in the forest. So we can eliminate choice A for that pretty immediately. Then we've got choice B, a Tlingit family applied for joint title. Well, no, it's got to be a head of the household that applies for up to 168 acres of land. So we can eliminate choice B there pretty directly as well. Then for choice C, a Tlingit individual applied for title to 15 acres within the Tongass National Forest based solely on his ancestors having continuously lived, hunted, and fished on that land for centuries until 1902. Well, if we're talking about the application of this one, we would have to actually go into the third paragraph here. And we would recognize this is where all of the details were from our upfront read. So we can see that the land and the allotment must have been personally used by the applicant as an adult before its inclusion in the forest here in paragraph 3. So getting a title based solely on the ancestors using it would not be approved. So we can eliminate choice C for that reason. And then we scroll down only at this time to look at choices D and E. D reads the head of a Haida household. Again, that's good. We know that we wanted heads of household up here. So we like the beginning of choice D at this point. Applied for title to 20 acres within the Tongass National Forest based on his having lived, hunted, and fished on that land from 1875 to 1900. Well, that fits all of our criteria that we recall at this point. And then choice E, a Haida individual applied for title to 80 acres within the Tongass National Forest based on her having been born in 1900 in a dwelling on that tract of land, which had been continuously used by her family for generations. Well, again, you wouldn't have been granted your allotment if it was based on family usage, according to the passage. It had to be based on individual usage. So this was a brisk run through 3 different specific inference style tasks using this example passage from Reading Comprehension Drill Set 1.